Hi, I'm Mykytiuk from Scrofano Law PC. For the next few minutes, I want to talk a little bit about reckless driving in the Commonwealth of Virginia. Virginia drivers who have never had any previous problems with the law are often surprised to find themselves in court on a reckless driving charge. And that's because Virginia has some of the harshest reckless driving laws in the country. By the time I'm done, hopefully you will know what will get you charged with reckless driving, what the penalties and impact may be, and how a lawyer can help you avoid a conviction. Now, I've practiced criminal and traffic defense in Northern Virginia for 15 years, and I've handled a lot of reckless driving charges. Most of them involve reckless by speed. In the Commonwealth, a driver can be charged with reckless driving if he or she drives at a speed over 85 miles per hour or exceeds the posted speed limit by 20 miles per hour or more. As I said, this type of reckless is by far the most common because it's pretty cut and dry. If the cop's radar shows a certain speed, it's reckless driving. Although it's less common, a Virginia driver can also be charged with reckless driving if he or she is driving in a way that police determine may endanger the life, limb, or property of any person, regardless of speed. Obviously, that's a very subjective determination. Now, although it's traffic court, reckless driving is not simply a traffic infraction. Under the Code of Virginia, it is a Class 1 misdemeanor. Now, a Class 1 misdemeanor is the most severe misdemeanor charge in Virginia, and a conviction can have lasting impacts on your future. If you're found guilty of reckless driving in Virginia, you may face up to 12 months of jail time and a fine of up to $2,500. While almost no one will ever actually receive the maximum penalty, the most serious reckless driving cases, we're talking about very high speeds, do expose you to some jail time. And in addition to criminal penalties, a Virginia reckless driving conviction may result in punishments by the DMV. A conviction will result in 6 demerit points being placed on your license. And depending on where you stand regarding demerit points on your license, a Virginia reckless driving conviction could result in your license being suspended for up to 6 months or more. Your conviction will stay on your driving record for 11 years, and it will stay on your criminal record for the rest of your life. And the expungement process in Virginia is very difficult, and if it's actually a conviction, you will not be eligible. So there are some real consequences here, and many people probably don't take these cases seriously enough. Many defendants will show up to court without a lawyer, plead guilty, and hope for a reasonable fine. And yes, you may get a fine, but once you plead guilty, you have a conviction regardless of what the punishment is. And with the help of a skilled lawyer, a reckless driving charge could be reduced to some other charges, for instance, improper driving, perhaps a speeding or other moving violation, or in some cases, even a simple equipment violation. Besides not showing up on your criminal record, these violations come with less severe penalties. So negotiating a favorable deal with the prosecutor is usually the first line of defense in reckless driving cases. Failing that, trying the case or convincing the judge to reduce the charge is the defendant's last hope. Having an experienced attorney who knows how to effectively lobby on your behalf could be the difference between a criminal conviction and a simple traffic infraction. Now, the factors that could convince a prosecutor or judge to reduce a charge to something that's not a reckless driving include a clean driving history or taking a driver education course, not to mention the underlying reason for the driving behavior. Again, discussing these options with an experienced attorney is your best protection to avoiding a criminal conviction. Now, if you're facing a license suspension, however, you may have the option of receiving a restricted license, also known as a work license or a hardship license. This type of driver's license permits you to drive under specific restrictions. It's generally provided by the DMV in Virginia. With a restricted license, you can drive to certain essential locations such as school, work, church, and depending on the discretion of the judge, going back and forth to manage your case. To obtain a restricted license, you'll need to petition the court with the help of an attorney. A skilled reckless driving Virginia attorney can examine the facts in your case, determine whether to pursue a limited driving license, and guide you through the process. Now, those who hold a commercial driver's license, or CDL, may face additional and even more harsh penalties. There are federal consequences that result from serious driving violations for those who hold CDLs. So a reckless driving conviction will not just get you punished by the state of Virginia, you will also get punished possibly federally. If you're convicted of a serious driving violation twice in a 3-year span, your CDL could be suspended for 60 days. If you're convicted of a third serious driving violation in that 3-year span, your CDL could be suspended for 120 days. So people with CDLs have even more considerations to take. A reckless driving violation can happen anywhere, but drivers are most at risk of receiving a reckless driving in Virginia on the major highways and freeways, 95, 81, 66, the Dulles Airport Toll Road, and Dulles Greenway, which tend to produce a larger number of reckless driving charges by speed. This is a significant reason why out-of-state drivers are more prone to reckless driving charges in Virginia. If you face a Virginia reckless driving charge and you're a resident of another state, the process for fighting your charges will be different than that of a Virginia resident. Because reckless driving is a criminal misdemeanor, not a traffic violation, an appearance in court is required regardless of whether or not you're out of state. This is not a charge that can just be dealt with through the mail. Now, for many people, traveling back to a Virginia courthouse may be incredibly difficult for whatever reason. On your behalf, a Virginia reckless driving attorney could petition to appear for you in court, saving you time and money on traveling expenses. The criminal penalties do not change based on where you're from. However, the Virginia DMV cannot suspend your out-of-state license, nor can they put any demerit points on it. What the DMV will do is report your conviction to your home state DMV. Your home state DMV will then apply any penalties to your driving record that would have resulted had your reckless driving conviction occurred in that state. Now, the bottom line is that reckless driving is an easy charge to pick up in Virginia, and you really need to take it seriously. Having a lawyer by your side will give you a much better chance of avoiding a criminal conviction and harsh penalties. Now, if you want more information about what I've just discussed, go ahead and click on the link below or give us a call.